Okay, thank you. Good evening, everybody, and welcome to tonight's Standards Committee meeting. If I can just ask you all, if you haven't switched your mobiles off, or put them on silent to do so. I'll make sure mine is on there. Practice what I preach. Apologies from anybody. Okay. Late items to be introduced by the chair. I have none. Declarations of interest, anybody? No. Minutes of the meeting held on the 1st of November. I wasn't here then, so if somebody moved the minutes.
Move is printed.
Okay, seconded. Thank you. Standards Committee forward plan.
Chair, I'll take this one. As you know, this year the Standards Committee have been maintaining a full plan of issues that you would like to look at over the course of the municipal year. Conscious that this is the penultimate meeting of this municipal year, but the report presents the full plan for approval and is an opportunity for the committee to add any items to the work programme, either for the next meeting or for the next municipal year that you think would be beneficial for us to take a look at. So anything relating to the code of conduct or the related codes and protocols that
Anybody like to add anything to that? I mean, obviously, as I said many times before, it's open. If there are any improvements that we think can be made to this, then it's an ongoing process. We should carry on with that settle. Alan, did you want to say? Oh,
No.
I did. No. Okay. Review the.
Just on the social media one, is there any idea when that's going to be best practice produced? Because we have a timescale for it.
We've not had anything happen with it.
It's something that I'm intending to draft in the near future or bring back to this committee at the earliest opportunity. I think.
Were you talking about external guide?
Well, when at the last meeting we talked about social media and apps, it's quite
Yes.
a discussion about it, didn't we?
Yes.
And we were talking about general guidance for use of social media could be developed by relevant officers, including the student points outlined in the meeting. So, I mean, is that what you're talking about?
Yeah, that's correct, Philip. I'll work up that protocol. Perhaps engage with some consultation with the members of this committee outside of the formal meetings and bring something back for approval in due course.
Yeah, because it was very much linked into. Isn't there already some social media guidance for officers?
Yes, that's correct. The council has
some of that.
It is an ongoing process. I think we were talking about this about 3-4 months ago when we first brought it up. So hopefully Alex will draft something up and we can all have a look and see if there's any improvements we can make to it or if it's highly acceptable. Standards Committee forward plan, is that you or?
Sorry, Chair, that's the item we were just discussing.
Sorry, review of the working together protocol.
That one is me as well, Chair. This is an item that was added to the Standards Committee forward plan at the start of the municipal year. As the report suggests, it's a key governance document for us within the council. It feeds into, although it doesn't form part of the code of conduct, it feeds into the code of conduct in that it talks about how councillors and officers can build effective working relationships. It's often used as a training tool for both councillors as part of the annual training programme and also officers in terms of training that Emily delivers to new recruits into the council and also refresher training on working in a political environment. It's also a helpful document for managing low-level conduct issues that perhaps fall short of a formal standards complaint, whether that is an employee conduct issue or a councillor conduct issue, but where those two cohorts coexist. Sometimes it's a useful document for guiding both officers and councillors on appropriate behaviour when they're working with each other. As you'll note, the protocol itself was last updated, I believe, in 2019. It's attached at Appendix 1 to the report. It covers some general principles relating to both points of similarity between councillors and officers, but also those key differences in terms of accountability and role. It also talks about the differing role of councillors, for example, the difference between cabinet members, ward councillors, scrutiny members, and the different requirements that those types of councillors might have. It provides guidance on maintaining to officers on maintaining impartiality and discretion when working in a political environment, and also guidelines for officers on attendance at things like political group meetings, and also guidelines on the rights and entitlements of both councillors and officers who are also residents of Derby when, for example, attending a neighbourhood forum meeting as a resident and not in their capacity as either an employee or member of the council. Hopefully the report is fairly self-explanatory and you've had opportunity to read through the protocol. And we're not recommending any specific changes to the protocol. We think it works in its current form, but obviously good practice to bring it before the Standards Committee from time to time. And if the committee has any views about where it can be developed, we'll obviously take those away and bring them back to the committee in due course.
Thank you. Helen, budget, no?
Yeah. What use is it?
I mean, I would say it's quite a useful document for us as officers in terms of in democratic services in particular, will quite often deliver training to other departments within the council about engaging with councillors, working with councillors. This document captures a lot of the key points around the different accountabilities that I hold as an officer compared to yourself as a member.
Okay, well, devil's advocate. What if people don't abide by the guidelines? Well, they break the guidelines. What happens?
This is a corporate document at the end of the day that is recommended to the full council by the Standards Committee. I suppose it would depend on the level of severity of how, you know, if certain principles within, if it was a councillor who was breaking certain protocols within this, certain requirements within this protocol, it may manifest itself in a standards complaint. Similarly, if it was an officer, depending on the severity, it could result in a disciplinary issue.
Standards complaints procedure anyway.
Yes.
What I'm saying is I don't understand why time has been spent on this if it has no particular function apart from this is what we'd like you to do, but if you don't, it don't matter, because that's basically what you're saying.
I don't think we are saying that, Councillor Graves. I think the working together protocol sets out an expectation of behaviour. I think that if there was a behaviour that did not meet that expectation, that would provide a framework within which a standards complaint could be assessed. So, for example, there are provisions in there around confidentiality, around the nature of briefings, those kind of things. I think that if there was, if a standards complaint then came into us, which said, in these circumstances, there was this breach of confidentiality and this behaviour, etc., I would, in assessing whether I felt there was a breach and in consulting with the independent persons, I would be signposting the independent persons to that protocol, given that it sets out an expectation of behaviour that that councillors are expected to and officers are expected to abide by.
I mean, it's an additional tool. I don't think there's any harm in having it. Obviously, you know, you pointed out about the procedures already, but there is no harm in having it.
Sure, may I also say, I think that having a document that also summarises and sets out the expectations of both sides of the equation within an organisation as unique as a council, because councils are pretty unique organisations in having the political and the non-political officer core. I think to have a document that endorsed by council that sets out that relationship is incredibly useful for sharing with new councillors in particular, occasionally reminding long-serving councillors, and also explaining to officers about how this organisation and those two groups work together and interact.
Okay.
I suppose it also provides some protection, some clarity for officers of what's expected of them with members and the relationship between the two. I think that's a thing we mustn't forget, because some members could be a bit oppressive in their approach, and they I'm sure occasionally, not to apply to anybody here, of course, but you know, it provides them with some sort of security that there is some protection in this, to to limit the amount of activity that the two sides deal with. There's just one other issue about on 3940, the bit about non-council members. Practice of co-opting non-council members to sit on various bodies is commonplace to the IER. I suppose that would actually apply to ourselves, wouldn't it?
Yes, absolutely. Yeah, that those
Doesn't actually say independent members, but just talked about co-opting non-council members, I suppose, in a sense, as we are co-opting.
Yeah.
Yeah, I think across our different committees, there are slightly different terms for the independent persons on standards committee, the independent persons on audit and governance. We have co-opted members on our children and young people scrutiny board, for example. This applies to anyone who is appointed to a council committee who is not an elected member of the council.
Yes, it's sort of generic term that applies to anybody in any committee who is not an elected member
Or an officer.
or an officer.
Chair, if I may, I think another point that's sort of pertinent is the vast majority of colleagues who work within this organisation have relatively little to do with councillors on a day-to-day basis, and it's something something that we in democratic services encounter from time to time is colleagues will come to us and say, we've had an inquiry from a council, I'm not quite sure how to respond to this or what the process is. And this is a really useful, I mean, it's quite a short document, it's 14 pages long. It forms the basis of some guidance that's published on the council's intranet, and it's a useful training tool from that perspective as well.
Hey, I think Alan thinks it's quite warm here, so he's trying to drag the meeting on a bit, so he's saying he's eating at home.
I thought this was a warm place.
Okay, volume and outcomes of councillor complaints 22-23.
Thank you, that's me. Thank you, Chair. This is the item in the open part of the meeting, item 7, which asks councillors, members of the committee to note volume and outcome of councillor complaints in 22-23 that's set out in the report. We had 4 complaints carried over from the 2021-22 municipal year. Of those, 2 complaints actually concern the same council and are broadly related, and both being investigated, and I'm awaiting the outcome of those investigations, which have been complex. 1 complaint has been investigated and the Monetary Office is seeking input on resolution, and that matter is now very close to conclusion. And in relation to the 4th complaint, the Monetary Office has consulted the Independent Person Advisory Panel, is considering the next steps. And I would like to come back to that and talk a little bit more about the committee in a moment. 6 complaints have been received in the 2022-23 municipal year to date. Those 4 complaints have been dismissed and 2 are still live, and this is the same point that I would like to come back to again. So unless you have any particular questions about those, that's a quick summary of what we have received and how it's been dealt with in 22-23. I'd like to raise a point with you, Chair, about that we think we might need to address in our procedures.
Okay.
So we sometimes have situations where we receive complaints which are, want a better expression, he said, she said type complaints. So the complaint comes in and it will set out a complaint against a councillor. Quite often that might have been an interaction that was witnessed by nobody else, and it was just a one-to-one. We will then go through the normal procedures that we have. So we will share the nature of that complaint with the subject member, share it with the IPs, and actually we'll get an entirely different account from the subject member. And when we go back to both sides, neither is able to offer any form of corroborating evidence one way or another. And we end up in an almost, you end up stuck essentially about what to do with this complaint. On the face of it, that complaint may suggest a complaint that would be, you know, of sufficient severity to worthy investigation, but were it to be investigated, it's clear that there is no evidence available to deal with, to find one way or another. So an investigation is almost a pointless task. Our procedures don't currently give us any form of method for dealing with that, for dismissing that complaint. And so some have actually, I think, 3 complaints that are currently stuck in that sort of scenario. And we would like to, and we've given this some thought as officers as to a potential addition that committee could consider adding to procedures to allow that circumstance to be dealt with.
Well, I think it's a good idea. I mean, you know, Alan and I have been on here long enough to know that there's always a bit of needle between councillors. Sometimes it can be councillor and you know, an officer. But if there's only two of them and one says he said that and the other one says no, he did, I mean, there's very limited scope for you, Emily, or Alex to act on that, because there is, as you said, no further proof to corroborate it. So, you know, the grown-up world we live in, right? Things are said in the full council meeting, in planning, in licensing, and sometimes you just have to sort of see it for what it is. It may be a, you know, heat of the moment thing that possibly didn't wasn't meant as an offensive remark by one or the other. But if there is no way to corroborate any one of their stories, then there is very little we can do, and sort of to carry on with it would be, in my opinion, wasting time and money. Did you want to add anything further, Matthew?
Just agrees. If there isn't any evidence at all either way, then what can you do?
Yeah.
I mean, I suppose you can do everything. The officers can do whatever they can to speak to both parties. But if there isn't a third party or some kind of evidence to corroborate either way, then, I mean, it should be taken seriously.
Yeah.
That's the main thing. It has to be taken seriously. And initially, you know, a full sort of investigation carried out, or at least discuss
Fact finding.
fact finding, yeah. But I agree. If you have, it's an impossible job to draw to a conclusion if both sides have different interpretations of what occurred. The addition is what that it was.
So we under the complaints procedure at paragraph 60, we reached the point where there is an assessment of the complaint, and as currently drafted, there are 5 grounds on which I can dismiss the complaint at that point. So that subject to the complaint was not an elected member of the authority at the time of the event, or is no longer an elected member. Subject to the complaint was acting in personal capacity rather than in their capacity as a member. Steps have already been taken effectively to remedy the situation. They've already resolved it. A similar complaint has been received, or the complaint may be considered to be vexatious, or even if proven that circumstances happen, it would not constitute a breach of the power of the code, and that's where it ends. So what we have thought would be the potential addition of the following paragraph, which says as follows: neither the complainant or the subject member is able to provide evidence to corroborate their version of events, with the effect that any subsequent investigation would be unable to conclude whether or not the councillor's code of conduct had been breached.
You've got to be careful there, because the subject member is not the complainant. So if somebody complains about you, Ajay, you're the defendant, not the person complaining. So therefore, you may not know that you've done anything wrong. So why should he have to have evidence that he's innocent? Surely the burden is on the person making the complaint. If the complainant hasn't got evidence, then that's the end of the matter. If it's just the way you worded it, they've both got to provide evidence.
It's neither the complainant or the, yeah.
Chair, if I may just add to that, it may be the situation where, as you say, things do get heated sometimes. Sometimes, you know, all of us say things we probably, if we had time to think about it, maybe we'd say it in a different way. There's different.
Much worse.
Well, maybe there's different levels of that. It could be that during the information gathering, the first phase of this, that there is some evidence on both sides of maybe not as bad as maybe A has suggested it would be, but the B person may have said, well, yes, I did say that. In hindsight, you know, I think it was a bit strong.
I think that would be covered though already under our procedures. I think I could deal with that under our procedures already.
It's resolved with a sorry or whatever.
Where For example, two members are sat in a meeting room waiting to have a conversation with officers. They have a conversation that one of them finds offensive in some way. They make a standards complaint about the behaviour of the other. The other one says, well, I didn't say that. I didn't say that. And the other one says, but you did say that. Did anyone else hear it? No one heard it. What do I do in that situation? So I'm just thinking through in my mind, Alan's suggesting it should only be if the subject member is unable to provide evidence.
I think there is a valid point that in the course of any fact finding, clearly you need to ascertain that there was actually no further evidence that, for example, in the example you describe, Emily, two councillors in a meeting room together, there wasn't someone next door who could overhear what was going on. So we have to take reasonable steps to ascertain that there is no other evidence. But having undergone that process and no evidence being forthcoming, then clearly we would look to.
I think we're making a mountain out of a molehill here. Look, the procedure is the same. You know, if a complaint is made, you or Alex and an independent member will look at it, and if you feel there was, you know, certain things said or done that should have been done, then you can ask the sort of second person who was there, whether it's officer, councillor, or male, female. Then it is in a way official complaint. You know, somebody's making a complaint saying I was in a room with this person and he said that and I said that. Well, okay, they'll give their statement to you. You can then approach, as you do now, the sort of defendant and say, well, you know, this has been made against you, did you say it? And if he says no, and you can find no further proof, then you act accordingly. Sorry, I missed you out then.
Yes, I'm a bit uncomfortable with trying to prescribe a dismissal of any complaint which is denied by the subject member, where the complainant cannot provide evidence as a procedural point. Because it seems to me that, I mean, as the monitoring officer, you're in a quasi-judicial role, and in coming to a view about what to do when a complaint has come forward, you have had comment from 4 independent persons about what weight to attach to this, and generally speaking, if there isn't any evidence that can be found to substantiate a complaint, it really comes to a view about what weight you can reasonably attach to it, given regard to all the circumstances. To just say, as there is no supporting evidence, it cannot be agreed, it cannot be supported, in all circumstances, seems to me to be going too far as a procedural requirement. It seems to me an element of judgment has to be made in those circumstances.
I think this is a grounds for dismissal. I don't have to take that ground for dismissal. So were I to consult with the IPs and the IPs were to say, well, on the face of it, this seems like a serious complaint, please, you would often say to me, can you ask the subject member if the complainant for some more information, wouldn't you? That's quite often something that you would come back to me with. If I was to go back to the complaint and say, well, noted the grounds of your complaint, please can you confirm if anyone else witnessed it or if anyone there's a record or anything else? No, that didn't happen. It's quite difficult then to take that complaint forward.
But I think, you know, we're going to be careful on this ground. I understand what you're saying, but if it's one individual against a, you know, for argument's sake, it may be a male against a female or a female against a male or somebody from, you know, different background, then whose word are we likely to attach more importance to? You know, how can we then say, well, you know, this person must be telling the truth and the other one might not be? Unless there's any kind of physical altercation that, you know, maybe can be picked up on the CCTV there. Obviously, there won't be much sound, but you know, the best you can do under the circumstances is what Emily is suggesting, because it would be wrong to sort of say, well, you know, this person is telling the truth and the other one isn't. You're open to all sorts of allegations and of you know, sort of favoritism or discrimination or any kind. So you've got to be careful.
I wonder if a slight change to the wording might address some of the Alan's point. If we were to say, rather than saying neither the complaint or the subject member, if we'd say, so as a monitoring officer has been unable to discover evidence to corroborate either version of events.
Yeah, Chair, and if there isn't any practical way, the person making the decision to find evidence of the complaint, you have no choice but to dismiss it.
Yeah, because you're going to go around in circles. So
Yeah,
there's a essence for you.
There's an element of obviously, you know, it's a job to do, but ultimately, you can't guess either way or make a judgment call either way. You just have to say on the balance of this, I have no evidence, therefore this has to stop.
Sometimes we would have complaints where we do make a decision on the basis of balance of probabilities, but that's when there has been evidence to consider. So we sometimes have investigation reports which have gone that way, where we have, you know, but there has always been evidence to consider in those circumstances. And in the circumstances on the balance of probability, I find that there has been breach or there hasn't. I think this is a slightly different situation, but how does committee feel about if I was to amend it, that proposed wording that way, that it would be that the ground for dismissal would be if neither, following the assessment, the monitoring officer has been unable to discover evidence to corroborate the version of events presented.
I'd be happy with that. That covers everything, because at the end of the day, it's your discretion, and if you know it's not going to go in and it's not going to teeth in it, you can look at it from now until next year. If there's nothing there, you've got to address it and dismiss it if there's something there. But let's be honest, if there has been a to and fro, nobody's going to admit to the fact that there's done anything. That's just the way it is. But this then is going to be down to you to make a decision and stop wasting your time if there's nothing there for you to carry on with.
I think the alteration there is sufficient to
Covered it, yeah.
move on with.
Has to be based on evidence.
Yeah.
The whole judicial system, I mean, this is now on this, not on this level, but you wouldn't have a judge that says, well, I think you're truthful, I'll go with you. It doesn't work that way. It has to be, well, what's the evidence before me? And I'll make a decision based on what the actual evidence is. If you haven't got that, you can't make a decision.
This isn't obviously it isn't a judicial process, but that said, it does have to comply with the principles of natural justice.
Yes, correct.
Ellen, final word.
Thank you. I think you brought this because you wanted to find an easier way to resolve something, which I think is a good idea in the first place. But I think you've opened a can of worms, because now if we add this extra one in where there is no evidence, there may be an implication that the councillor who's being complained about is hiding something because he's not giving the evidence or she's not giving the evidence, and we need to be aware as a committee that what we don't want to do is give that inference. You know, I mean, if somebody comes along and says the councillor did this, and the councillor says, well, and you investigate, and the councillor doesn't give you any information, are they hiding something? Does the recommendation infer that they're hiding something? And is that what can be used? At the moment, what you do is you dismiss the case, which is not saying that you're not saying anything apart from the fact that you're not going any further with it.
Well, I have to dismiss according to one of those grounds that I read out before. Okay. So I have to dismiss on the basis of, and the decision letters state the basis on which I dismiss, if I dismiss or take it forward. So when those decision notices go out as to what will happen next, we identify which of paragraph 6.
I'm just trying to think ahead of, if something like this comes forward.
Sorry, Chair. I think in the example you described, Councillor Graves, if clearly it would be very much on the complainant to provide evidence against the councillor. If the councillor then chose to withhold evidence that might defend their position or incriminate themselves, then they're almost guaranteeing that it's then going to proceed to an investigation. And I also think that I'll let Emily clarify this, but I suspect that this paragraph we'd have to make an assessment of the severity of the complaint before considering to dismiss a complaint on this under this paragraph, because if the allegations were particularly egregious, then even if there was a lack of evidence, it might still be deemed in public interest to undertake an investigation of some form, whether that's internal or external. If the allegations are perhaps more trivial, then it's probably less in the public interest to commit more officer time to investigating it or commission an external investigator to pursue the complaint further. I think there'd be an assessment of severity before we sought to dismiss a complaint under this new paragraph that we're discussing.
And that's something that the IP could consider.
We're just looking for wording for this type of complaint. Right, I don't think it is just reasons. I mean, I know Alan here has suggested that we don't need it, but I'm wondering which of the reasons we currently have Alan would suggest you use in that case.
No, I'm not saying we shouldn't have it. What I'm saying is we need to be careful about what it might infer. And also, as my original point was, it's the councillor that's being complained about. And so therefore the councillor doesn't have to provide any evidence. It's almost like a police state, isn't it? You know, the policeman has to find the evidence that you've done what you've done.
That's what most people go, no comment.
Yeah, exactly.
Surely the councillor isn't. The councillor, if they were supplying evidence, they would be admitting it, wouldn't they? Or they would supply evidence to the contrary. I mean,
I would
just by saying no, that didn't happen. That's the end of it from the councillor's point of view.
I mean, I think I'm supportive of the suggestion there with his input as well. I think I make this point though. If we didn't do this and said no, we're not agreeing, that wouldn't mean that it would make the situation any better.
No,
because Emily would then just not make a decision. It'd be stuck in the ether.
Which is
so it's not going to actually make any real difference. It just makes it more precise in terms of the process, so that we aren't saying that there's 3 that are continuing year after, because there's never a revolution.
We're trying to find a bit of a fudge with the current
Couldn't you
procedure.
say we are unable to pursue this this complaint
So
without giving any further reason?
sorry.
Chair, we haven't actually seen this wording. It's just risen today. It's a sort of item which hasn't there hasn't really been an opportunity for longer term consideration. Would it be possible for the proposed amendment or addition to the code and procedure to be to come forward to the next meeting, perhaps, so we can properly decide?
I mean, I don't know if it's going to be any clearer for the next meeting, because we are looking at a paragraph that's been added to the code of conduct as it is. So I really honestly don't see the benefit of saying, well, we'll look at it in 8 weeks' time. But if the majority of people want to do that, obviously I only have one vote. I'm not saying that, but I fail to see the significance of putting it off until the next meeting. Alex.
Chair, might make a suggestion. You could look to delegate the decision, and if Emily were to come back with the formal words in consultation with the wider committee, if the committee were to agree in principle to the general thrust of this amendment, we could finalise the wording outside of this meeting and circulate it to the members of the committee for
Second my suggestion, thanks for that point, Alex. I think Emily's pretty clear in what she's saying. She's not asking for much to go in there, just an additional couple of paragraphs in that paragraph, just to make it clear, because like you said, by bringing it back in 8-10 weeks' time, this isn't going to be any different to what it is today, and it's going to be the same with the kind of members, so can we not come to an agreement?
What I propose, I think what Alex has said, if that's acceptable to all, Matthew, Alan, I think we proceed along that basis, rather than to, let somebody feel they've been left out. So if you do what you've just said earlier on, Alex, and get it sorted, and then even outside of this meeting, it can be. Okay.
Right. Yeah, agreed. Yeah.
Yeah, could I just raise a different point, actually? It's about the word dismiss, which is in the report. All complaints have been dismissed. And I wondered how the decision is conveyed to the complainant. I mean, assume a letter is written to them, and I wonder what is said in that letter, because the word dismiss, I actually looked it up in the Oxford Dictionary. I mean, apart from being sacked if you're dismissed, it says in relation to a complaint is either treat as unworthy of serious consideration, or bracket law bracket refuse further hearing to. Now, clearly, in this sense, it's the latter use, and it's correctly being used. And I'm wondering, when a letter goes to the complainant in informing them their complaint has been dismissed, is it actually couched in terms which are appropriate to the situation? Clearly, some complaints come through which are quite vexatious or maybe politically motivated, and dismissal is just the right term. But I was thinking of a case where somebody complained about something, and I thought he had a really good case really for the complaint, but a personal view which I conveyed, no doubt with other IPs, to the monitoring officer, is that I didn't think, nevertheless, it went beyond the threshold of seriousness which would warrant the expenditure of going for further investigation. And it seemed to me that if this person received a letter which says your complaint has just been dismissed, it would be pretty wounding and really unsatisfactory for the reputation of the operation of the standards process. So really, I'm seeking some sort of assurance, really, that the actual reply to the complainant actually does give some, it does actually relate to the sort of circumstances and will take into account the feelings of somebody who, in this particular case, is a very genuine person, put a lot of time into it, and deserves proper reply, which isn't wounding.
So when we respond, we reference the grounds on which, under the complaints procedure, a complaint is being dismissed. So at the start of this, when I read out those grounds under paragraph 16, grounds 8E, we specifically state which of those grounds we are relying on for dismissal. So in that example you just gave, for example, Peter, we, I think, I can't remember, I'm not sure exactly which one you're trying to do, the complaint, even if proven, would not constitute a breach of the paragraph of the member's code of conduct as identified by the complainant. So I did not reach that threshold. So something may have happened, but it wouldn't have led to a breach. So we do make sure we set that out. I mean, Stephen usually crafts, sends those out after a discussion with myself about the grounds, and we spell that out, don't we, in those?
I mean, we're of course assuming hypothetically that the complaint is genuine. It may not be. You know, we don't know this, right? So I think the best under the circumstances is what's been suggested, and we'll sort of go along with that if nobody else has anything to add. Okay.
So I agree with what Peter said.
Yeah.
I think it's quite important.
We do provide that clarity in our response.
I think of quite nuanced
Yes.
Ideas ourselves, I think, amongst us.
Yeah, we make it clear that what process we've gone through in considering the complaint. So the consultation with yourselves and my deliberations, and then the grounds on which it won't be taken forward further.
Of course, it'll go out to both parties, you know, so that none of them feel that the complainant doesn't feel that nobody's listening to him, and then the defendant doesn't feel that nobody's taking his word or her word for that matter.
Will be dialogue, Chair, won't there?
Yeah.
With both parties, and then I should think it'd be clear after officers have spoken to them to say, you know, we need, what other information do you have that could provide us with more information to take this forward. And if they can't provide that, and it was just one person with another person in a room, and unfortunately that response is, it might be a little bit wounding to be felt like you're not being listened to, but if you don't have that information to back it up, it's going to be the end result is going to be it can't be taken forward. And however that is written, it's how it is.
Let's hope there are jolly nice people like us and accept him. Okay, exclusion of press and public. Doesn't seem to be a great deal here of either.
Read out.
So I'm watching online, Chair.
Yeah. So you just read out the exclusion.
Okay. To consider a resolution to exclude the press and public during consideration of the following items. That under section 100A of the Local Government Act 1972, the press and public be excluded from the meeting during discussion of the following items on the grounds that they involve the likely disclosure of exempt information defined in paragraphs 1 and 2, part 1 of Schedule 12A of the Act, and that the public interest in maintaining the exemption outweighs the public interest in disclosing the information. Okay. Item 9. Is that you?